Well, good morning, everybody. This is our fourth workshop in our series, Reimagining Tax Administration, running social programs through the tax code. And I'm just going to frame this session within the course of all the sessions, what we're trying to do here, and then turn it over to our moderator, Margot Crandall-Hollick. So what the session today is about is looking at program eligibility rules for social program benefit programs. So it doesn't just include the eligibility rules for tax programs like the child tax credit or the earned income tax credit, but we're trying to look at other programs too to see what we can learn about these eligibility rules. Now, this session comes after we've already had like a baseline session dealing with the IRS and how it actually processes returns and some of the challenges that can occur in processing returns that taxpayers may face. And then we had a session on really the EITC and CTC population, the poverty population, the characteristics of households in the United States, in particular low income or no income households. And that was to sort of show, okay, well, who are we asking as we deal with social benefits through the code? Who are we asking to interact with these very difficult processes that we learned about in the first session? And then last week, we had a session on sort of administrative burden and aspects of design that could maybe minimize or mitigate administrative burden, particularly with respect to the population that we had just described in the workshop on poverty. And that leads us now to thinking, well, now that we've thought about administrative burden, we know the current state of the IRS, we know some of the characteristics of the low income, no income households. What are the actual requirements that are current in the tax law and in other programs? And that will eventually lead us to thinking about what kind of changes do we need to make if we really want to reduce administrative burden and run successful programs in the code. Future sessions will include not only those recommendations for change, but also thinking about due process. That's our next section, dispute resolution and protecting the rights of these taxpayers, and as well dealing with cultural change in the IRS, which keeps coming up in every single one of our sessions. So with that, I'm just going to turn it over to Margot Crandall-Hollick, who can introduce herself. Margot, you want to open up the session, please?
So thanks, Nina, so much for having me moderate this amazing panel. My name is Margot Crandall-Hollick, and I work at the Congressional Research Service on refundable tax credits for low-income populations. So I do a lot of work on the EITC and the child credit. It's been a busy few months, I know, for a lot of us. So in this workshop, the fourth of 7 workshops in this series hosted by the Center for Taxpayer Rights, we're intending to explore a variety of topics around eligibility rules. What are those program eligibility rules for family tax benefits? And we're going to be probably focusing on the refundable tax credits many of you are familiar with, like the EITC and the child credit, but we also will look at health tax benefits, I assume. And how do these eligibility rules compare to the eligibility rules for other non-tax benefits for families and families with kids? We're also going to look at what are the challenges for families in navigating these rules and in the IRS and administering them, and what is the relationship of these rules to improper payments of these credits. So we're going to get into what improper payments are, what improper payments aren't. Hopefully that will be illuminating for many of us. We're also going to look at different approaches, both internationally and at the state level, to minimize taxpayer burden and to minimize these challenges. And finally, we are going to, in light of all that's happening legislatively and potential revisions to some of these eligibility rules, and I'm speaking, of course, about some of the proposed changes in the Build Back Better Act around the child tax credit, I think we're going to look at what challenges remain and what are the trade-offs that policymakers may consider when they're designing eligibility rules that meet families and families with children where they are and reflect their circumstances, but are also administrable for the Revenue Collection Agency. Today we have an amazing panel to talk about these issues. Elaine Maag is a principal research associate at the Urban Brookings Tax Policy Center, where she studies income support programs for low-income families with children and with a focus on tax benefits like the EITC and the child tax credit. Emiliy Lin is an economist at the Office of Tax Analysis, OTA, at the Treasury Department, a position she's held since 2001. Her research primarily focuses on taxpayer compliance, the distribution of the tax burden, and tax topics related to families and children. Chye-Ching Huang and Kathleen Bryant are both from the Tax Law Center at NYU Law. Before starting as the executive director at the Tax Law Center, Chye-Ching was the senior director of economic policy at the Center on Budget and Policy Priorities, CBPP, here in DC, where she works on the analysis and design of a wide range of federal tax and fiscal and economic policy proposals. Kathleen Bryant is a legal research associate at the Tax Law Center, and before joining the Tax Law Center, she also worked at CBPP for 3 years, where she conducted research on federal tax policy, federal appropriations, macroeconomic trends, and paid family and medical leave policies, which are also in the news these past few months. Elena is the program manager of the Office of the Taxpayer Advocate at the District of Columbia's Office of Tax and Revenue, where she works to ensure access to representation, provides education and outreach, and strives for the improvement of the tax system for all district taxpayers. And as a district taxpayer, I want to thank her for that. And finally, Cathy Livingston is a partner at Jones Day, where she focuses currently on tax-exempt organizations, but she is also a leading authority on the Affordable Care Act, which I'm sure will be very interesting when we're talking about eligibility rules. Prior to joining Jones Day in 2013, Cathy was the IRS's first healthcare counsel, the principal legal advisor to IRS senior leadership on all aspects of the Affordable Care Act. And so just a little housekeeping before we get started. I'm sure questions will come up as panelists make their presentations. We're generally going to hold those questions till the end of everyone's presentation so that everyone has time. If there are technical questions at the end of someone's presentation, I will ask those of the panelists so that we don't interrupt anyone's flow. Okay, so to set the stage, again, when we're thinking about family tax benefits, there are a variety of eligibility rules, and we're not going to get into every single one of them today, but there are major factors that routinely affect the amount of an eligibility for a variety of tax benefits, and which we'll probably touch upon. And there might be ones on this list that we don't touch upon, but it's important to keep in mind that when you're determining whether you're eligible and how much you may be eligible to claim, these factors come up over and over again. And they include the income of the taxpayer. So earned income is a big one, especially for the EITC, it's in its name. Prior to 2021, the child tax credit for low income taxpayers phased in with earned income. Marital status can also affect the formula that you use to calculate a benefit, and certain tax filing statuses are actually ineligible, for some benefits. The number and presence of eligible children can affect the amount of a tax benefit. We often refer to them as qualifying children. And so that's a big factor that I assume we will spend a lot of time discussing today. And finally, this does come up, taxpayer IDs and the qualifying child ID numbers also can affect whether a taxpayer can receive a benefit. So those are all kind of big picture things that can affect eligibility and on the amount of a tax benefit. And so because qualifying children and family benefits get so much attention and is really the focus of this panel, I wanted to give a big picture overview again of some of the major criteria that determine whether a taxpayer can claim a child for a benefit. So again, I'm not going into all the weeds, all the exceptions to the rule, just a big picture overview of what these main factors are. And one thing to keep in mind, especially with the two factors, relationship and residency, that we'll talk about today, is that we don't issue tax credits directly to children, right? We issue tax credits to adults who have a connection with a child. the taxpayer who can claim the qualifying child. And so relationship and residency tests are one way to make that connection. The relationship test effectively says, you know, you have a biological or legal relationship. So it allows taxpayers to meet this test if they are a parent or a grandparent or an aunt and uncle. In addition to meeting that test, they generally also have to meet a residency test. So in that case, that test is the test that says the child has to live with the taxpayer for more than half the year. It's also sometimes called the 6 month and a day rule. And so there are exceptions to this in cases of temporary absence, but this is a kind of a big test that we'll probably talk about in more detail during the panel. And finally, although this isn't a test that's about connecting taxpayers to children, there are age requirements, and they do vary, right? There are age requirements. So for the child independent care credit, the child has to be, in most cases, under 13 years old. For the EITC, those age limits are higher. For the child tax credit, the age limit used to be under 17, and these age limits are based off of the age of the child on the last day of the year. That age limit for the child tax credit was temporarily increased so that 17-year-olds could be eligible, could meet the age test for 2021. And so I think, well, I can't get to the next slide. So I think an important thing to keep in mind when we're looking at the relationship and residency tests is why do we have these tests? What is the reason behind these tests? You know, why is that the connection that we've made between a taxpayer and a child? And this is one explanation that I found very illuminating from a blog post that Nina did in June for procedurally taxing. And essentially she said the relationship and residency tests are proxies for care and control, standard found in many benefit programs and the main care standard found in some tax credits in other countries, including Australia. So that's like one idea of why those tests are there, but I'm gonna hand it off to Elaine now to get us started on how other benefit programs connect children and adults.
Good morning. I'm so excited to be part of this. Thank you, Nina, for organizing these, and Margot. I want to flag, because Margot didn't herself, that she has been kicking out a lot of work on the American Rescue Plan. And so if you are confused about what the law is, I suggest looking up her name and Congressional Research Service, and you can see a lot in very digestible format. It's been quite helpful to me. But what I want to talk about today is claiming benefits for a child. And this is, you know, not surprising, but the tax system isn't the only place that provides benefits to children. And so this table was taken out of a Kids Share report, which is authored by many of my colleagues at the Urban Institute. Jean Sturley, Heather Hahn, Julia Isaacs have all made, you know, huge contributions over the years. But the first thing I want you to take away from this is that tax provisions are very important for families with children and in subsidizing children. So roughly 40% of all child subsidies from the federal government come through tax provisions. They aren't just going to low-income children, they're going to children across the income spectrum. The second group of benefits are health benefits, so Medicaid and CHIP. And then you have income security programs, and then they get you know, smaller after that. The thing I want you to notice is, though, that all of these are operated by a different agency, and they have different ways of parsing out who a child is. At the end, I'll talk about why it matters that we don't have a uniform definition and some costs associated with those, a uniform definition. So the issue is, as Margot said, that we don't just pay children directly. So we have to find the right adult to give that money to. And just a brief overview, although there's lots of exceptions embedded these. When we think about Medicaid and CHIP, it generally is that tax filing relationship that we're looking for to benefit. But you go to this marketplace to apply, and you know, as I flipped through the pages of the application, it's a little bit unclear you know, from the beginning, whether you're going to be eligible. The second source of programs, those Social Security programs, look at survivors benefits and SSI. And they're looking for a legal representative that has been assigned to the child or a surviving parent to distribute those payments to. That may or may not be the same person that Medicaid has identified as the right person to receive the benefit on behalf of the child. When you get to TANF, sometimes the unit will, a typical unit would be a mom and children that are all related to each other. But the TANF unit can include an unmarried partner that's living in the household. So it's a little bit more expansive than a tax definition, which is sort of, as Margot described, confined to those legal relationships. And then SNAP, which is the food stamp program, comes in with an entirely different definition, which is people who share meals. And so this may be the TANF unit, and it may be the tax unit, and it may be something different. And then I do note that we do provide one thing directly to children, and those are those education programs that were sort of at the bottom of the chart. So this can create confusion amongst families in knowing what they're eligible for and whether they ought to pursue getting benefits. So tax credits, I won't go through this again, rely on residency, relationships, and then there's that support test in the child tax credit that's not in the earned income tax credits. So I'll bump that since Margot went through that. But there's a new standard being discussed, and I'm just calling it the Ways and Means Standards because it's in the legislation that's being talked about right now. And so the first question when I think about changing the tax standards is, do we really care if there's no overlapping claims? So as long as a child doesn't appear on multiple returns, does the tax agency, are they really concerned with who's getting the benefit? At some level, they're concerned because we have different benefit amounts for different families, so different income levels. And so they don't want to have children scurry from high income households to low income households and end up paying more benefit than they've intended. But within income class, does it really matter? And sort of the Ways and Means is saying it doesn't matter so much. And so we can think about a little bit more relaxed standard. But we have to balance the costs of, this opens up the opportunity for more overlapping claims. So I can implement a standard that says whoever cares for the child is the appropriate claimant. But if it's not tied to things the IRS can verify, then there may be more people making claims on a particular child. And so we have to think about, there's an administrative cost to that for both the claimant and the IRS. But of course, there's a benefit to the child when it works out that the child is actually most likely to receive the benefit then. And then I think there's questions that we have to answer about whether the tax code is really suited to looking beyond the tax unit. And this is stuff that's been covered in earlier presentations here. And the question is, how flexible can the IRS be? And what sort of different supports does the IRS need in order to administer a different type of claim? So it's often talked about amongst Nina's friends that we need some sort of social benefits administrators that are used to reaching out to families and sussing out, what is the child's situation. The second piece of looking beyond the tax unit, though, is thinking about, can a benefit go with a child who may live in multiple households throughout the year, but doesn't live in the same tax unit? So can that benefit flex with the child on that level too? And then I was reading recently some work by Ariel Gerald Kleinman that suggests that overlapping claims might not be as much a problem as we think if the definition of who can claim the child becomes more intuitive. So if it's the person who's caring for the child, they might know they should claim these benefits rather than going to a tax form and being confused about who should claim the benefits. And that, of course, is something that's untested, but we'll be thinking about. But the reason all this matters is because children qualify for multiple benefits. They don't just sit in the Medicaid box or the child tax credit box or the SNAP box. They can be eligible for multiple benefits. And though it's true that most families don't participate in all benefits for which they're eligible, they often will participate in more than one benefit. And when the system doesn't identify a child the same way all the time, we risk people missing out on benefits they're eligible for simply because they've gone to one office and learned about eligibility for benefits and not been, notified that there's other benefits with other definitions that they might be eligible for. It also, though, leads to the other problem of someone is found eligible, for example, for a SNAP benefit, and they might assume they're eligible for the child tax credit or the earned income tax credit. So they go and claim those, but it turns out they're not eligible for those benefits for, another reason. And so it's confusing for the administrators, and it's confusing for participants. And there's also just, I can't help but point out the inefficiency in all this, in that we have people sitting at multiple agencies determining eligibility for the same family. I was at a conference recently where mom said she had put together her notebook of forms that she needed to go claim benefits at her SNAP office. And she was there, and then, she has all the right stuff and she's ready. And then she looks at me and she's like, why do I have to do this again for the tax system? That doesn't make any sense. And it is costly, and we're, so for the individuals, but it's also, it seems horribly inefficient for all these agencies. But then when I think about, what's the most likely uniform definition we would use, it seems like we would go toward that tax definition that's being used right now. And that's because the healthcare programs are essentially using it. The tax credits, and as I showed in the first slide, those are sort of where the real dollars are being, really pushed out broadly to families with children. The problem, of course, is that if we move to a definition only relying on the tax unit, we're going to create winners and losers, and those might not be the people that you want to be winners and losers. So we might want to make sure a TANF benefit is staying with the household that is eligible for it. We might not want to have it move. One reason we might want it to stay in that TANF unit is because the TANF unit can move and change throughout the year. So if I'm caring for my child goes to live with her dad later on in the year. If we're both low income, that TANF benefit can move to where the child is. And so tax benefit definition, if we end up relying on that, in my view, as it's structured right now, is very blunt, and it does not actually reflect how families live their lives. And so I think, this leads me to the conclusion that we have to do some hard thinking about who we're delivering tax benefits to. We need to figure out a reasonable way to deliver benefits where the child is. And if we can, along the way, create some uniformity that helps people understand the benefits and reduces these administrative overlaps, then that would be, an extra benefit in my book. And we ought to be thinking about doing that. So that is my overview of what happens for benefits for children in multiple agencies. And I will end there.
Thank you, Nina, for inviting me to the workshop, and Margot for organizing it. I'm very grateful for the opportunity here to present the paper I worked on a couple of years ago with my colleagues, Jenny McCobbin, who was retired from Treasury last year, and Kara Leibel, who is at the IRS Research. The usual disclaimer applies. The findings and views in this paper are those of the authors and do not necessarily represent the position or policy of the IRS or the Treasury Department. Next slide, please. So for today's audience, I'm sure that I don't need to introduce you what an earned income credit or the EITC is. However, some of you may not be aware that EITC has a relatively high non-compliance level. The so-called improper payment rate, which I will define a little bit later, has fluctuated in the range from 23 to 27 since 2002. And for fiscal year 2020, the improper payment rate was estimated at 24%, meaning that for every EITC dollar claimed, about a quarter is claimed in error, either because an ineligible taxpayer claimed the credit or because an eligible taxpayer overclaimed the amount he or she is eligible for. So having this aggregate statistic may be helpful, but they do not tell us how to view the associated non-compliance. In particular, they do not tell us enough about the social welfare loss of the error, such as what value might we place on an EITC dollar paid in error, or how might this value compare to the cost of reducing errors through enforcement or policy changes. Although our paper does not offer direct answer to these questions, we explore these considerations by looking more closely at the errors associated with the EITC qualifying children. Next slide, please. So this is a little bit dense, but the point here is that the Improper Payment Information Act of 2002, or IPIA, and the subsequent amendments defined improper payments and the reporting requirements for the agencies that administer the program. Although the term payments generally refer to transfer programs, the OMB guidance includes refundable tax credits in the definition of IPIA payments, and the IRS has reported improper payments estimates for the EITC since 2002. It should be noted that this reporting requirement is duplicative for the IRS. IRS has long established a tax gap program, which evaluates the non-compliance in the entire system, including non-compliance with refundable tax credits. In fact, the improper payment estimates and the tax gap estimates are based on the same underlying data from randomized audits of individual income tax returns. Next slide, please. So this is a slide on EITC eligibility rule in 2017. Margot has gone through this. The main points I'm trying to make on this slide is that there is a long list of tests to meet if a taxpayer would like to claim a child for the EITC. Some of these tests depend on the child's characteristics only. For example, if the child has a valid social security number, or if the child meets age requirements. But also the relationship and residency test depends on the characteristic of both the child and the taxpayer claiming the child. So for residency, the child must live with the taxpayer in the United States for more than half the tax year. For relationships, the child must be the son, daughter, stepchild, a foster child, a sibling of the taxpayer, or a descendant of this. So these rules suggest that if the child's specific test is not met, the child cannot be claimed by any taxpayer for the EITC. However, if the relationship or residency tests are not met, there may be another taxpayer who may claim the child. And it is also possible for a child to meet all the requirements with respect to more than one taxpayer. So when that happens, there are additional considerations, often referred to as the tiebreaker rules, that determine which taxpayer is the one legally entitled to claim the credit. Next slide, please. So given the complexity of the qualifying child test and the fact that the IRS lacks information to verify many of the qualifications without auditing the taxpayer, it can be expected that taxpayers make errors on the claims, either intentionally or not. Failure to meet the qualifying child test contribute to a large share of the estimates of EITC improper payments. Using random audit data from tax year 2006 through 2008, my co-author Kara found that returns with qualifying child errors accounted for about over half of EITC dollars claimed in errors. That's 53% there. Next slide, please. So motivated by the estimated error rate and error patterns, we explored several research questions in our paper. So the first research question in our paper is the following. Who are the taxpayers who claim children incorrectly for the EITC? Are they related to the claimed child at all? And if so, what is the intensity of their relationship? And the second question is that why don't the correct parents claim the EITC? Although we do not exactly know whether the non-claiming parent is truly eligible for the credit, to the extent possible, we determine from our data this parent's eligibility. And finally, what is the social welfare loss and the net revenue loss caused by the wrong person claiming the credit? Next slide, please. So as mentioned earlier, one commonly used data set for studying individual non-compliance is the IRS's National Research Program, or the NRP, which includes a stratified random sample individual income tax returns subject to audit. Our data span from 2006 through 2011. For this year's, the NRP's EITC sample includes over 2,000 returns per year claiming EITC sufficient to produce top-line annual improper payment rates. So the data also includes information on specific EITC eligibility criteria and the reasons for audit changes. Combining the 6 years of data, our sample has over 12,000 observations for more detailed analysis. We also, for this paper, use other administrative data to generate the estimates, including Social Security records, individual income tax returns, and certain information returns such as W-2s that report individual wages. And the statistic I will present are annual averages of the weighted samples that present the population over the 6 years of our study period. Next slide. So the table here shows the types of qualifying child errors in our sample. We calculated that about 31.4 million children were claimed per year. And according to the random audit data, 4.8 million children were claimed in error. Some of these children failed to meet the rules pertaining to the child only, and therefore they cannot be claimed by any taxpayers. Removing these children from our initial sample resulted in a population estimate of about 3.4 million children per year. These children, while being claimed with a residency, relationship, or tiebreaker error, did not break any other qualifying child rules. Therefore, these children could potentially be correctly claimed by another taxpayer. These 3.4 million children represent 71% of the children claimed in error. And in terms of dollar amount, we estimate that the error associated with these claims account for about 38% of all EITC overclaims. Next slide, please. So who are the taxpayers incorrectly claiming the EITC? From the information recorded by the examiners in our data, we learned that in the vast majority of cases, the children claiming error meet the relationship test with respect to the taxpayers. About 47% are the son or daughter of the taxpayer, and 37% are qualifying relatives. And also, about 16% of the children claiming error have lived with the taxpayer during the year. So taken together, only about 12% failed to meet both the residency and relationship test, whereas about 11%, the light blue cells on the top right corners, are claimed by relatives who lived with the children for some time during the year. And a small fraction, about 3% of cases where taxpayers do not meet both the residency and the meet both the residency and relationship test, but the child is not a qualifying child, likely because the taxpayer does not win the tiebreaker rules. Next slide, please. So our strategy for the analysis is to match children claiming error to their non-claiming parents using Social Security records. So the Social Security file we used links a child to his or her parents, and it contains the parents' Social Security numbers where available. And for US-born children, typically Social Security numbers are applied at birth. So the first step of our estimate is to find if a parent or parents other than the taxpayer audited by the NRP can be identified from our Social Security records. And for the step, if a non-NRP parent is identified, we search for the tax and third-party information return of the parent to better understand his or her income and credit claiming situation. And finally, we determine whether the parent could have claimed the EITC. Next slide, please. So this slide shows the result for the first step and the second step. That's whether any non-claiming parents are identified, and if so, evaluate their income and credit situations. The first column shows the number of children, and the second column shows the shares of children. So we can see that about 21% of the children, for them, we could not find the Social Security numbers for any parent of the child in the Social Security data. This situation could occur because the child's parent might have been deceased at the time the application for the child's Social Security was filed, or individual other than the parents, such as a relative or a state foster care agency, filed a Social Security number application. It is also possible that some parents are not eligible for receiving a Social Security number at all. So next, for about 20% of the children, the only parent found in the Social Security data was on the same NRP return. In almost all cases, the parent is the taxpayer that claimed the child in error. So clearly, this parent failed the residency test or the tiebreaker rules, but we don't know if there is a correct taxpayer as stipulated by law who have lived with the child for the required duration of the time and met all the other eligibility requirements in order to claim the credit. For a small number of cases in this category, the parent themselves are dependents of the NRP taxpayers who claim the child in error. This could be a family member or a married partner that supports both the parents and the child. So for the next group, in about 19% of cases, at least the one non-claiming parent was identified, and the parent did not appear on an individual income tax returns, either by filing a return or being claimed as a dependent by someone else. We use information returns such as W-2 to examine the income of this parent. Only 27% of these parents had any earned income found through the information reports. And those who had earned income, the amount was generally very low. This result suggests that the majority of these parents could not have claimed the EITC anyway. And again, the NRP claiming taxpayer could have been a family member who did not meet the residency test, or a married partner who failed the relationship requirements. And lastly, in 4% of the cases, the parent found already claimed the child for the EITC, duplicating the NRP claim. So all of this leaves us with only about 36% of the children in our study, totaling slightly over 1.2 million, for whom we identify a non-claiming parent filer. Next slide, please. So now we turn to the parent returns of this 1.2 million children. And there are about almost 1.2 million non-claiming parents in our study. After further investigation, only 47% of these parents appear eligible. This includes about 0.5 million parents who are linked to 0.6 million children. The parents we found ineligible either already claimed the maximum number of EITC children, had income above the phase-out range, or had other issues indicating ineligibility on their tax returns. Some of them could be excluded from eligibility for more than one reason. This situation indicates that a parent may allow other family members to claim the child, knowing that they themselves cannot claim the credit. Next slide, please. So this gets to our last research question. How big is the total amount of the foregone credits? We estimate that an average of 561 million in EITC was foregone each year from 2006 to 2011. This, in fact, is a small amount relative to the total EITC overclaims. To put the estimate in perspective, we first calculate that the overclaims associated with this 0.6 million children are about $1.4 billion. And the overclaims associated with any children claimed with qualifying child errors is about $5.8 billion. Therefore, as a ratio, for the 0.6 million children in our analysis, only 39% of the overclaims could have been paid to the correct parents. And the value of the foregone credit represents only about 10% of the total overclaims attributed to qualifying child errors. So to conclude, we see that the vast majority of children claimed with qualifying child errors are related to taxpayers, either meeting the relationship test or having lived with the kids during the year. There are a variety of scenarios we identify that explain why the children are claimed in error. About 60% of the children did not appear to have a parent who could be the right taxpayer. For the children we identify who file a tax return, over 1/2 are ineligible. And for those eligible, the credit they would receive is small relative to the amount claimed by the NRP taxpayer. So taken together, this suggests that the official improper payment rate slightly overstates the monetary loss to the government due to the foregone credits. And whether it also overstates the social welfare loss, I guess the answer depends on the policy goal and your personal views. Given that the Congress apparently has enacted the specific and the very complex rules for EITC eligibility EITC qualifying child eligibility, it is likely that some of these children are not the intended beneficiaries. And this concludes my presentation. Thank you.
I'm going to turn it over to Chye-Ching and Kathleen.
Hi all, I'm Chye-Ching Huang. My colleague Kathleen Bryant, who's pulling up the slides, will be stepping through a paper that we wrote with Professors Peter Whiteford and Jane Miller. And I'll then discuss how that paper relates to issues of error and a tax gap. Please note that when we go beyond the descriptive work that's in the paper itself and move to some of the implications for some significant policy proposals that were released after the paper, we are giving the views of the Tax Law Centre alone and not those of our co-authors in the UK and Australia. Thanks, Kathleen.
Thanks, Chye-Ching, and here's a link to our paper if anyone wants to look it up afterward. So in the UK, Australia, and New Zealand, the design of their child tax credit and benefit programs meant that many families received advance payments of benefits that they were ultimately ineligible for because their circumstances changed over the course of the year. We found that large numbers of families experienced severe financial distress after they had to repay sometimes large sums to the government. That in turn created substantial problems for the agencies responsible for administering these benefits, and lawmakers had to respond by revising program design. There are trade-offs involved in changing program designs to minimize repayment risks, but these countries' experiences do show that lawmakers in the US should place high weight on preventing repayments when designing a longer-term advanced child tax credit program. I won't spend too much time on the specific reasons why some families might need to repay some or all of their Advance CTC under the program's current design for tax year 2021, because I'm sure many of you are already familiar with the program structure. But to quickly recap, certain changes between a filer's 2020 tax return, which was used to estimate eligibility, and a filer's 2021 tax return pose some repayment risks. Changes in income will only really affect the CTC amount that some higher income filers are eligible for, because the benefit amount is flat for most filers. But changes in family circumstances could also pose repayment risks for filers, specifically changes like a parental separation or a change in child custody arrangements that affect whether a filer can continue to claim a child for the CTC. Low-income filers are fully protected from repayments of this nature in 2021 through a safe harbor, but moderate income filers may face repayment obligations for those reasons. And as policymakers are thinking about the transition from the temporary program in place now to a longer-term design, they essentially have three broad options. First, they can continue to follow the UK's, Australia's, and New Zealand's general approach and continue estimating eligibility for payments a year in advance. Retaining the basic 2021 approach of the US CTC would fall in this category, though policymakers could choose to retain or expand existing protections on top, like the safe harbor. These other countries' experiences do give us a glimpse into what the US could expect if we keep going down this road. The second option would be for policymakers to eliminate income-based repayment risks by using, for example, past year's income data to set benefit levels, but still mandate real-time, immediate reporting of any changes in family circumstances and penalize families that fail to do so with repayment obligations. This is essentially how Canada's child benefit works. This reduces but does not eliminate repayment risks. The third option is what's outlined in the Ways and Means Bill and offers the strongest repayment protections. Other countries we looked at are a concrete illustration of why the Ways and Means approach of avoiding substantial repayment risks is attractive. And for the sake of time, I'll only describe the UK's program in detail today, but I'm happy to discuss the other countries that we analyzed in Q&A. In the first few years after the UK's working tax credit and child tax credit were implemented, about 1/3 of tax credit awards were overpaid. The UK's tax credit amounts varied more dramatically by income than the US CTC, and so the majority of overpayments were driven by changes in income partway through the year. But a House of Commons Treasury Committee inquiry found that a sizable share, about 30%, were caused by delays in reporting relevant changes in circumstances. And again, these are the types of changes that we're worried about in the US for those with lower or moderate incomes. Unsurprisingly, large surprise debts to the government are not a positive experience for families. Repayment obligations imposed substantial financial hardships on many in the UK. And the vast majority of respondents in surveys reported experiencing financial difficulties from tax credit debt, and some specifically shared that they were forgoing their basic needs to pay it down. So here are the big takeaways from the UK that we had. One is that financial hardship from repayments can be severe and that repayments in the UK were pervasive. Two is that repayments can create risks to participation in receiving credits regularly. One study found that 56% of those with tax credit debt were uninterested in attempting to claim the credits again in the future, even if they became eligible, showing that the threat of large debts deterred program participation. The third is that wide-scale repayment obligations caused real political problems. Headlines condemned the government for the scale of the debt crisis throughout the early 2000s, and several parliamentary investigations were conducted on the issue. And in large part because of that, in the UK, they had to iterate by creating safe harbor policies. And we found that safe harbor-like policies layered on top of a basic structure that created repayment risks were not stable in the long run. They instituted a generous income disregard, which was similar to the US safe harbor of £25,000 in 2006. But as political winds changed over the subsequent decade, that number dwindled and was ultimately cut to $2,500 in 2016. And our last takeaway is that IT improvements are important, but are not a panacea for this problem. Some overpayments of the UK's tax credits were caused not by delays in reporting changes in income or in circumstances, but by agency delays in processing those changes. And while, again, IT improvements certainly were important and helped over time, repayment challenges have continued to persist in the UK, even as the country keeps iterating on its IT infrastructure, and even as the UK transitions away from the legacy tax credits I've described to an entirely new universal credit program. And again, Australia and New Zealand's programs offer similar takeaways to those that I just detailed. Canada's program does pose less severe repayment risks than the UK's tax credits, and that's because they calculate Canada Child benefits for the year upfront using the prior year's income data. So income-based repayment risks are essentially eliminated. But repayment risks still remain because families are required to immediately report any changes, with caregivers facing potentially steep repayment obligations if they're delayed in reporting that their child no longer lives with them. And in all the countries we looked at, we found that people couldn't be expected to perfectly and immediately report changes in family circumstances like that. So then, how severe might the repayment risks under the 2021 Advance CTC in the US be? They could be sizable for moderate income families that experience changes in circumstances and have incomes in the phase-out region of the safe harbor. Consider, for example, a father of 2 young children and a teen who earns $60,000 in 2021. He and his wife finalize a divorce during 2021, and advance payments are distributed to the father based on their 2020 tax returns. But when he goes to file in 2021, he's ultimately ineligible to claim the kids for whom he received the advance payments. Without the safe harbor, he would have to repay $5,100 in advance payments. The safe harbor reduces his CTC debt to $2,100, which is still sizable. And because his income is above 200% of the poverty line, he would not be statutorily protected from IRS referrals to private debt collectors. The Ways and Means Bill makes important changes to minimize these repayment risks in the Advance CTC. Under the bill, 2022 would serve as an additional transition year and follow the same CTC design used in 2021, except for a larger safe harbor amount per child that would fully cover 12 months rather than just 6 months of advance payments. In 2023, several major design changes would be introduced. An income look-back would allow higher income families in the phase-out region to establish eligibility for the CTC using their incomes from the prior tax year, if doing so would increase their credit amount. Eligibility would be determined on a monthly rather than an annual basis, allowing the CTC to follow the child if they change residences partway through the year. And most importantly, it establishes a policy of presumptive eligibility. This means that when a caregiver files their taxes and prospectively claims that a child will be in their care for at least the next several months, all payments issued to that caregiver for the next year will be considered presumptively valid until the following year. And if that child changes residences, the new caregiver would need to raise their hand to alert the IRS that payments should go to them instead, at which point the period of presumptive eligibility for the original caregiver would end. This policy would protect caregivers from sizable repayment risks if their circumstances change dramatically and they're delayed in reporting or unable to report that change to the IRS. And I'll pass things back over to Chye-Ching to elaborate a little bit more on the Ways and Means proposal.
Thanks, Kathleen. So two quick observations. First, and happy to talk about this more in Q&A, this is really a rock and a hard place situation. There are really very many important design considerations for setting up the monthly structure that bolts on to the eligibility rules within it. And there are some unavoidable trade-offs when making that design decision. And our paper really just emphasizes that the repayment risk hard place can be very, very hard indeed for a large number of families. You know, perfection on all dimensions isn't really an option. And I think given how we saw that widespread hardship play out in other countries, the broad structure of the Ways and Means proposal is sound in that respect, although it does come with some trade-offs. And second, repayment risk is essentially defining error into existence in a way that is unnecessary. To my view, that would repeat a broad dynamic that we've seen over and over again in the credits, which is that high weight on both extremely precise targeting against some particular goal, plus a really high weight on deterring dishonest actors, who are an extremely small portion of filers, can lead to designs that create new risks of hardship for much broader swaths of honest filers. And in this case, it would be those family members who don't know about or don't fulfill their obligations to update the IRS immediately when circumstances change, and the risk that they face is this repayment risk. And that leads me to this topic of imbalance in reporting and analysis of refundable credit error compared to other parts of the tax gap of taxes that are owed but don't get paid voluntarily on time. The next slide shows that the refundable credits overall, including the EITC, CTC, AOTC, are responsible for just 10% of all taxes that don't get paid on time voluntarily, which leaves 90% of it elsewhere, including in sources of income that flow very disproportionately to higher income people. Underreporting of pass-through business income, for instance, is about a quarter of the tax gap, and the highest income filers overall are responsible for about 28% or perhaps more of that tax gap. So I'm going to leave that in place while you also, just up on your screen, while you consider these things that don't seem to sort of match with that overall share. That 10% of tax gap error, especially the EITC and CTC, gets pages and pages of annual reporting and agency financial reports, and it goes into great detail on the rate, amount of improper payments, estimates of the root causes and actions taken to reduce them, and reduction targets. Quarterly scorecards provide further detail on actions taken by the agency to reduce those overpayments. And as we've heard, those estimates are based on lagged data, but with attempts to update them to be as close to current circumstances as possible. And as we've seen, there are intermittent reports and studies, very helpful, such as the one that Emily presented, that go into even more detail looking at the causes of those errors. What about the other 90% of the tax gap? Well, you get reports that come out at a schedule that is intermittent and not set at any set interval. It can be between 2 and 5 years between those reports. That report covers the whole 100% of the tax gap, including the EITC and CTC, so they get reported again as part of this process from the same audit sample. But no single part of the tax gap reporting goes into anywhere near as much detail as in the annual refundable credit reporting. It's often based on quite old lagged data with no attempt to update the data to match, for example, continuing losses in the staff that audit the most complex business returns, the rise of issues such as cryptocurrency and so on. And many analysts have reported that this creates a bit of a doom loop where so much focus on the EITC error as opposed to other parts of the tax gap feeds the desire for complex targeting and processes to reduce error, which introduces more tripwires that lead to more error. Researchers including Brown, Washington, and Floyd have discussed how this imbalance may also feed upon and reinforce gendered and racialized views about who is deserving of scrutiny and who should face high administrative hurdles. The other side of the coin is that much higher dollar amount of sources of non-tax compliance are far less visible to the public and policymakers. This has happened because on the refundable credit side of things, they are treated differently. Prior administrations have made the call, incorrect as a matter of law in my view, that refundable tax credits have to be reported not just as part of the tax gap, but as part of the strict statutory and regulatory reporting under the improper payments regime, including the Payment Integrity Information Act of 2019, the most recent statute in that long list of IPERA statutes. That's why I consider it a very welcome thing that Treasury and the IRS are now proposing steps to fix this imbalance. Commissioner Reddick has said that they are going to make tax gap reporting more regular, more detailed, and with more attempts to incorporate information closer to real time. And in fact, under Treasury Secretary Mnuchin, Treasury proposed in its last annual financial report, taking EITC and CTC error reporting and making it just part of that strengthened tax gap framework. They revisited the assumption and concluded, correctly in my view, that it does not have to be part of the improper payments regime. And the basic reason is that that regime was set up to address weaknesses in internal controls within federal agencies for payment accuracy. This is things like contractor payments being made erroneously to deceased people, or people found guilty of prior federal tax fraud that should be on the non-pay list, for example. And those are the sorts of things administrations can largely fix on their own. But as we've heard over and over again in the EITC CTC era, that's just not the root cause of EITC and CTC error. It's not the Bureau of Fiscal Services not matching up payments to the right people, for instance. So what we see is over and over those reports passing notes back to Congress about the need to, say, address paid preparer regulation or the complexity in rules or other things that really need legislative action to address. So to my mind, and as Nina said, it's in the chat, it's a really long-standing issue. These are pretty important structural improvements on the horizon to how tax credit error should be reported on in the future. Robustly, regularly, with the same sort of careful research that Emily has presented, but in context and in proportion to much larger sources of the tax gap. Thanks, Margot.
Thank you, Chye-Ching and Kathleen. Could you guys post in the chat your study, a link to your study? I think a lot of people are looking forward to reading that. And I'll turn it over to Elena.
So thank you again for the opportunity to be here today to discuss this issue. So I am Elena Fowlkes. I am the program manager of the Office of the Taxpayer Advocate in the District of Columbia. So what I hope to be able to share with you all today is, one important factor when we're thinking about refundable credits and reimagining social policies through tax, because a lot of states actually couple their policies with regard to refundable credits and items like that to the federal rules. So as we kind of think through this, I thought it would be helpful to think through at least the District of Columbia's experience. The DC Earned Income Tax Credit has actually been coupled to the federal EITC since it began in 2001, which is when the District of Columbia adopted the Earned Income Tax Credit. And at that time, it was equal to 10% of the federal EITC and is phased up over time. It started out as 10% and then moved to 25 and 35 and 40%, which is where we are now. So currently, the District of Columbia has a credit equal to 40% of the federal EITC for working families with a qualifying child. However, we have made some significant changes and have expanded our credits in an interesting way. And we're scheduled to make even bigger changes coming up in 2022. So for those taxpayers that claim an earned income tax credit with a qualifying child, again, they can claim a credit up to 40% of their federal credit. However, the rules for qualification established in the Internal Revenue Code apply to the eligibility for the DC Earned Income Tax Credit. And what that means for a taxpayer in the District of Columbia is they have to go to the IRS, they have to qualify for their federal credit, they have to meet all of these definitions and criteria that we've been discussing this morning. And then when they file their district return, they have to do it all again. And they have to make sure that they're establishing the residency, relationship, the support, they meet the income thresholds. And while DC piggybacks off of a lot of these federal requirements and federal criteria, we can still independently audit and deny the credits. So just because somebody receives the credit at the federal level doesn't necessarily mean that they're going to get the credit at the district level. And this does introduce a bit of complexity and difficulty on behalf of the taxpayers who really do need these credits. And so one of the changes that DC has made, and what DC actually does differently, really comes back to the Tax Revision Commission, which is something that DC instituted as part of the Tax Revision Commission Reestablishment Act of 2011. So the commission was established in 2011 and was intended to provide recommendations that made the tax system more fair, broaden the tax base, made the district more competitive, encouraged job growth, all while modernizing and simplifying the tax system and increasing transparency. So in 2014, the Tax Revision Commission completed its review and issued a report. And it came out with a number of recommendations, a lot of recommendations with regard to a bunch of different tax types. One notable recommendation was that the district should increase the maximum DC earned income tax credit for childless workers and expand the coverage of the EITC. And part of this recommendation was based on the fact that the earned income tax credit, according to the commission at that time, was heavily tilted towards workers with children. So at that time of the report, it also noted that DC had one of the nation's most generous earned income tax credits for workers with children. So there just wasn't the political will at that time to expand that credit. But it went in and it wanted to think about, what can we do differently? What can we expand? What can we change as part of our tax policies in order to help this population that really doesn't get a whole lot out of the system because they don't have the qualifying child, or they don't meet the criteria that the IRS has set forth for having a qualifying child in the home in order to meet the criteria for getting that larger credit. The recommendations set forth by the Tax Revision Commission were ultimately accepted in 2015. So DC made some changes that impact a number of taxpayers in the district. The childless worker earned income tax credit, rather than being 40% of the federal credit, is now 100% of the federal credit. So if somebody in DC qualifies for the earned income tax credit on their federal return and they do not have a qualifying child, they can actually get 100% of the credit on their DC return as a DC earned income tax credit. But more interestingly than that, the credit is available to more people than would be available to them at the federal level because we have a higher AGI threshold. So at the federal level, the maximum AGI limit for 2020 was 15,820. So somebody who makes more than that is phased out of the credit. But in DC, the limit is $25,833. So there's a little bit of a threshold there where somebody may make more than 15,820, but less than 25,833. So they are not getting a federal credit, but they still qualify for the earned income tax credit in the District of Columbia, and they do receive that at the maximum level in DC. And DC did that in order to, one, account for the high cost of living that we have here, and to acknowledge the fact that even if somebody makes what may be considered a reasonable income at the federal level, in DC that may not cover all their expenses. They might still have a desperate need, even though they're making money elsewhere and the federal return is thinking that it might not be necessary to supplement them in quite the same way. And then there is also another bucket of eligibility, which is a DC non-custodial parent earned income tax credit. So in the District of Columbia, if you are a non-custodial parent, you are a DC resident taxpayer between the ages of 18 and 30, you are the parent of a minor child who does not live with you, and you are required by a court order to make child support payments that you actually make in the credit in the year that the tax credit is sought, then you can claim an earned income tax credit as well. And this credit is claimed on the DC individual income tax return and is calculated with a number of schedules. So there's a little complexity in calculating the credit and in making sure that you're claiming it correctly as far as on the administrative side. But the childless worker earned income tax credit, which is made up of both the workers who don't have a qualifying child in the home, as well as the DC non-custodial parent earned income tax credit, together actually supplement the existing program and dramatically expand what is available to somebody that does not have a qualifying child in the home in the District of Columbia. So the question was, did it make a difference? And yes, absolutely did. In the year following the expansion, more than 10,000 additional workers claimed the DC earned income tax credit than the previous year. And keeping in mind that DC is a relatively small place, that is a 26.8% increase in the total claims for the earned income tax credit in DC. And this increase is attributed to the claims by childless workers, both the non-custodial parents and those whose incomes would not have allowed them to claim the credit at the federal level. So there's also a number of upcoming changes that were just very recently passed to the DC earned income tax credit, which is actually entitled the Earned Income Tax Credit as Basic Income legislation. And it allows for an increase to the total amount that can be claimed. So for beginning in tax year 2022, we're going to phase in an increase to the total credit. For 22, 23, and 24, that goes up to 70% of the federal EITC. For tax year 25, that's 85% of the federal EITC. And for tax year 2026 and beyond, that's 100% of the federal earned income tax credit. However, it's going to be paid out in an interesting way, because beginning in tax year 2022, 40% of the DC earned income tax credit will be paid up front as a lump sum to taxpayers who make those claims. And then if the remaining amount is more than $600, they'll get it paid out over 11 monthly installments. One thing to note is that this is not an advance credit. This is earned. So this has already been calculated on their return. And then notably, there is no change for childless workers because their credit was already 100%. And then their payout won't change for tax year 2022. And then for tax year 2023, all DC earned income tax credit refunds that are over $1,200 will be paid out in 12 monthly installments, including those for childless workers. So, you know, that's a brief discussion on, sorry, let me go back, on exactly what is happening here in the District of Columbia with regard to the earned income tax credit. But I do want to point out a couple of things that include that the fact that as long as DC is still coupled with the federal earned income tax credit rules, we're still going to face the same challenges and limitations with regard to the narrow definitions. We are going to be subject to the same issues with regard to who is caring for a child, where does the child live, and all of the challenges faced by those families in determining who the proper claimant for those credits is. And we're also inheriting a lot of the challenges with regard to the overpayments, the erroneous payments, and the eligibility challenges that somebody is facing. So while DC has shown a willingness to decouple from the federal rules, the bulk of the earned income tax credit claims are still coming based on the federal earned income tax credit eligibility. And this means that, that we need to look at who the qualifying child is, who is the proper person claiming those credits. And it won't be until the federal rules are updated and changed that the resulting difficulty can be resolved at the state level. And when the states make those changes, then it really amplifies the challenges for the taxpayers. So if a taxpayer at the federal level has a claim denied or a claim audited and removed, and they're forced to repay that federal credit, the law requires that they file an amended return in DC and report that change. So then they're actually paying back the DC credit as well. So they're paying back both credits, and that financial difficulty faced after not understanding the credit or erroneously claiming credit at the federal level will then be essentially doubled at the DC level as well, especially once those credit amounts are increased. So, you know, that's one thing to think about was we're rethinking the impact of these definitions and the impact of these requirements at the federal level is that there is a waterfall effect that it goes down into the states as well. So the impact overall can be really, really significant in a lot of different ways. So that is what I have, and I appreciate you guys letting me be a part of this discussion as well.
Thanks, Elena. I'm going to turn it over to Cathy.
Thank you very much, Nina, for having this whole series and for inviting me to join this really extraordinary group of folk who know so much about all these different benefits. I'm going to come along and maybe summarize from a legal perspective themes that you've heard in every single one of these presentations about why it is so gosh darn difficult to deliver these benefits through the tax code. And also then, if it is so hard, why are we doing it? So as you've heard, our tax filing system is designed to be retrospective. You file a return once a year and you report with respect to the prior year, meaning that at that point, all of the facts and circumstances are locked into place. But when you're trying to provide benefits on a real-time or advanced basis, that's going to come in conflict, because if you have something like, as Elaine pointed out, this 6 months and a day rule for residency, on an advanced basis or prospective basis, you can't know for sure whether or not you're going to satisfy that requirement, which leads us to exactly where Kathleen and Chye-Ching were pointing, and that is the potential of having to pay some or all of the benefit back, which then puts you into, as Chye-Ching put it, the doom loop, which is a really unfortunate thing. Then we have the issue that the low-income people who are very often the intended beneficiaries of these payments are often not otherwise required to file a tax return. They don't have enough income. But if we're going to deliver the benefit through the tax system, we're going to force them into some amount of filing behaviors. That adds administrative burden. And we've seen that with the economic impact payments, where even though the IRS has created a streamlined process, you nevertheless have to affirmatively interact with the agency and file something. And what you are putting in through that simplified portal is considered a tax return. Next, we have, as was pointed out, particularly by Elaine and Margot at the beginning, Internal Revenue Code definitions that are really designed to define income and collect revenue, and they can be hard to reconcile with definitions that are used for other benefit schemes, which are trying to achieve different kinds of objectives. And if you try to reconcile and have a single set of definitions, you're going to produce winners and losers, or perhaps definitions that are less well suited to the tax purposes that the IRS is supposedly trying to pursue as the tax enforcement agency. Then we have a fundamental problem about access to data. The IRS does not have real-time information about income, marital status, where children are living, where anyone is living. We know for the premium tax credit, we don't have real-time data on whether employers are offering coverage or who the employer is. This creates, again, real risks that if you're paying out benefits on an advanced basis, the IRS is not able to validate at the time that those benefits go out, those payments go out, the eligibility requirements. This puts much greater burden on the taxpayer to have to inform the IRS of real-time changes. And as again, as Chye-Ching and Kathleen discussed, that even in the Canadian system, that can produce some real severe burdens because it can be difficult to be that timely. It also puts huge pressure on the agency to be able to process whatever comes in on a timely basis. Tax refunds are offset by your outstanding debts to the federal government. That could be student loan debt, that could be past tax debt, unless there's an explicit statutory exception. So that can mean that even though we offer someone a benefit, unless it has been thought through and addressed in the statutory system, it can be clawed back against something you already owe the federal government. And then we have the culture issue at the IRS, which several people have referred to and that Nina has done lots to elevate and elucidate. The IRS lacks resources to do outreach to encourage people to claim benefits. It is fundamentally and has been historically a law enforcement agency. And this is exacerbated by, as Emily has pointed out, and as others have mentioned, the emphasis on this improper payments reporting, which plays to the IRS's status as a law enforcement agency, and the expectation that it's a law enforcement agency is just not an equal emphasis. But that can be very intimidating for potential beneficiaries. They don't see the IRS as a friendly agency that's there to help them. And the IRS just doesn't have the personnel, the data, the full culture to be able to be welcoming or as helpful and supportive as it wants to be. And I want to be very clear about this. This is a systemic problem. It is not a problem of the people at the IRS. The people at the IRS very, very much want to help. They want people to get everything that they are entitled to. They want to get the information out. But when you don't have enough people to open the mail or answer the phones, that's a fairly significant threshold issue. Elaine asked this very good question. Is the tax code suited to looking at things beyond the tax unit? Is the tax code really a suitable place to be running all of these benefits? Why, with all these problems, are we doing this? Well, now back to what you may have learned through Schoolhouse Rock. The US Constitution plays a role in all of this. And this is the appropriations clause that's in Article 1. No money shall be drawn from the Treasury, but in consequence of appropriations made by law, and regular statement and account of the receipts and expenditures of all public money shall be published from time to time. What this means is that you need to have congressional action in the form of an appropriation in order to be able to spend money. Where there's discretionary spending, those appropriations are made on an annual basis, and we have seen far too often in recent years that that is not a smooth functioning system. It's subject to government shutdowns, continuing resolutions, last minute deals being cut. And as I'll discuss in a minute, even more significant potential interference. Where there's mandatory spending, that means that the authorization for the spending and the appropriation allowing for the money to actually be dispersed are usually in the same piece of legislation, though sometimes we end up with appropriated entitlements where there is still a need for an appropriation or periodic legislative action to fund what is otherwise the mandatory spending. You have things like CHIP, where they can expire, the statute expires periodically and has to be re-upped in order to make it possible to do the spending. Just to give you a sense of what I mean by the kind of interference that it can occur if you are relying on the legislative process to give you an appropriation, we can look at an element of the Affordable Care Act, the Risk Corridors Program. This program was created to last for 3 years to try and deal with the fact that insurers first entering the exchanges had no history. So it was very difficult for them to be able to be certain that they were pricing their products appropriately, and they could end up with very significant losses, which might have been a deterrent for them to enter the program. And so the Risk Corridors piece of the Affordable Care Act created a statutory formula and said that if there were revenues that exceeded a certain threshold, they'd have to be paid into the government. If there were losses, there would be payments out to make up for them. There seemed to be consensus that it was not a zero-sum game, and so there could be payments that exceeded whatever was pulled in. HHS was asked by Congress how the payments for the Risk Corridor Program were funded, what was the appropriation authority, and HHS responded that to the extent that they needed to pay out more than they pulled in through the program, the program management appropriation for HHS would be available for those payments. The immediate response from Congress at that point, which was in the hands of a different party than the party that had been in the majority when the Affordable Care Act was enacted, was to place a rider on that program management appropriation, which prohibited its use for appropriations to pay for risk corridor payments. And they did that in 2015 and then again in 2016. Last 2 years of the program. And what that meant was that there accumulated under the statutory formula $12.3 billion in payments that the executive branch recognized as obligations of the federal government, but there was no money to pay them. That led to furious litigation. Multiple cases were filed. They came up through the Court of Claims, through the Federal Circuit, and ultimately to the Supreme Court. So in 2020, we finally had a decision in this case, Maine Community Health Options versus United States, which actually consolidated multiple cases, in which the Supreme Court said these were indeed obligations of the government, and the government had to follow through and pay them, but the route for payment was through something called the Tucker Act, which basically meant that all of these parties had to sue and make claims rather than automatically getting paid, because the Supreme Court completely recognized the validity of congressional action with that rider on the appropriation. Long story short is that if you have something that is subject to the annual or periodic appropriations process, the political factor comes in and you cannot count on that program actually being funded. I have a little note here that this phrase disappropriation, this term disappropriation, is actually coined by Matthew Lawrence, who's a law professor who wrote an excellent article on this whole topic that appeared in the January 2020 issue of the Columbia Law Review, if you'd like to read more about it and see some more circumstances beyond the risk orders where this has happened. So the solution to this particular problem that has been used now numerous times over the past, I'd say 20 plus years. I've had the privilege or responsibility of interacting with several of them, most notably the premium tax credit, but also the Hope and Lifetime Learning Credits or early education credits that appeared in 1997, is something called the Permanent Indefinite Appropriation, which funds tax refunds. And here is the statutory language in case you haven't recently cracked Title 31 of the US Code to take a look at it. What this in effect means is that Congress has in place a permanent appropriation, not one that needs to be renewed. And it's not subject to a dollar cap. It is elastic and it is equal to whatever amount needs to be spent to pay tax refunds. And as you'll see in the highlighted part at the bottom, that includes refunds due from refundable credits, including the premium tax credit, including the child tax credit. And so the use of the tax system is in large measure a response to the political risk that other kinds of social benefit programs could be enacted when there's one kind of configuration in Congress, but could be defunded when there's a different political configuration, and they can be defunded without having to repeal the whole program. And that creates a great deal of uncertainty. And if the uncertainty associated with potentially having to pay back an individual's payment is enough to deter people to seek these benefits, you can only imagine what the uncertainty caused by it's here this year and it's gone the next could potentially be. So I'm going to end with just one example. There are many, many examples that are like this, but just to show you, well, if this is the reality and we're going to continue to go through the tax code, we're also going to have to do a lot of patching and spackling to try and make things work for how people actually live their lives. The premium tax credit, and it's not the only one that works this way, has a specific provision that says a married couple must file a joint return in order to claim the premium tax credit. There are many reasons that individuals who are married would not file a joint return, even though it often produces adverse economic consequences. Sometimes there's no choice. There can be somebody who's married whose spouse has abandoned them and they haven't been able to go through the legal process of divorce. There are married couples where one spouse is a victim of spousal abuse and for their own physical safety needs to remove themselves and can't interact with the other spouse to file a joint return. In the case of the premium tax credit, this particular issue was addressed through regulation to try and make it possible for a taxpayer who is married nonetheless to be able to claim the premium tax credit for a period of up to 3 years, notwithstanding the fact that they're not filing a joint return. But the number of times that this kind of patching and spackling has to be done is just growing probably exponentially. And then there's always the risk that these kinds of regulatory fixes will be subject to challenge. If you think of King versus Burwell, which also went all the way to Supreme Court, where there was the need to make some interpretations consistent with the policy behind the credit with respect to what happens when you have a state exchange or a federal exchange. Again, the political forces are not just present in Congress, they also can be using litigation to affect how the benefits are actually delivered and under what circumstances. So I suppose the theme is "'Twas ever thus," and hats off to all who are working so hard to deal with these problems and figure out how they can be mitigated in some form of legislation and policy. And that's it for me.
Thanks, Kathy. Thanks all of the panelists. I guess I wanted to start, I don't see any questions in the chat. So I think I wanted to start with kind of a big picture question that all of you can answer if you want to. And it's kind of a theme that seemed to run through several of the presentations about this current definition in the tax system being considered maybe relatively rigid. You know, there's this relationship test and there's a residency test. And this desire to move to a more flexible definition to reflect people's actual circumstances. But is it correct, do you guys think about it as a trade-off between flexibility and the ability to administer the benefit? Is that how you think about it? And if it is how you think about it, is there a way that you kind of think about balancing those two issues?
I think it depends a little, Margot, because I think some types of inflexibility actually create administrative issues in the sense that you end up with potentially more systems set up to really precisely target. And then, I think the repayments risk is an example of that, an entire sort of apparatus that then needs to exist to sort of deal with that sort of widespread type of interaction with people when you're trying to claw back debts and explain how they occurred and why they occurred and how people should avoid them in the future. So I think it does depend a little bit on the issue. I mean, I think another example is the ability of families to decide in a scenario if there is sort of good relationships between different adults that might be within the universe of people that you think might be caring for the child in some way or another versus, against one of the different parts of the way to get at that, giving them the ability to sort of split the credit or decide between themselves. That type of flexibility, it certainly requires an additional administrative apparatus to allow that, that election to take place, but it also potentially comes with, the reduction of some other attempts to kind of, figure out who the right person is in the family, and also have to prove that. So that's an unsatisfactory non-answer answer, but it's my first attempt at one, and I'm interested in what other folks have to say.
I would just add on that I think it's extraordinarily important to think about whether a program can be administered. And I think about in the context of, it used to be that the earned income tax credit had pretty broad bipartisan support, and that has really changed. Even when, President Obama and Paul Ryan were, proposing nearly identical expansions to the earned income tax credit, it was not passed through Congress. And the reason is what other folks have talked about, that there, are questions about program administration and whether people are committing fraud and whether these are errors. And one party suggests that they're not going to expand a program that is full of errors. So you want to make sure that this administration question is dealt with carefully so that you can maintain support for these programs that really do amazing things for families and provide substantial support.
Here, Kathleen or Emily want to weigh in? Or Elena?
I do think Elaine makes an excellent point. Administrability is critical, and this is where the IRS is a difficult place to be if you're trying to get rough justice, because the agency is set up to come to within pennies a particular answer about what somebody's tax liability is or what somebody's refund is. I don't have enough experience with some of the other benefit programs to know how they might deal with something on a more rough justice basis if you get not quite the right number of SNAP dollars on your card, or if Medicaid spills over to a month or two beyond where it should. But the whole IRS infrastructure is set up not to tolerate that, which is lacking in compassion, but also probably we're falling into, from my perspective, a significant problem in this country with the politics around the moral construct of poverty and the notion that people who are claiming benefits and aren't claiming the right amount aren't in good faith trying to interact with the system and do the best they can with the system that doesn't necessarily make itself easy, but are instead somehow non-compliant, therefore doing something illegal, and therefore are deserve whatever the adverse consequences are. And so I'm not quite sure how to reconcile all of those things. Maybe we accept that if we're going to have to use the tax code and the tax system to do some of this, and that it's not going to be very good at rough justice, then maybe we think about these, which can we mitigate, which is most counterintuitive, which is most helpful, using Emily's work to think about where are the errors coming up, how can we weigh our choices to go after the things that are most likely to trip up good faith people and deny them benefits they should otherwise receive.
So I think that in my view, there's also a significant risk in introducing a lot of flexibility. Flexibility is great. You know, we want the tax code and these benefits to reflect, you know, how people really live their lives. But at the same time, you have the potential of making this really complex. So people have to understand, do I qualify for this as well? And it might be a situation where two taxpayers don't agree who took care of the child, or, you know, something to where you're introducing too much complexity into the system. So I think we have to find that balance between really having something that's modern and that makes sense and that fits the, you know, the real world, while still keeping it simple and streamlined, and then communicating those requirements to people in a way that they can understand. You know, we can go to conferences, we can discuss what the rules are, you know, but this is our job. This is what we do. For somebody who doesn't do this on a daily basis, are they going to be able to understand, you know, what they have to do in order to be compliant with these requirements as well? And I think that it's going to be a tough balance to strike. And if we don't go into it with that balance in mind, I think that there is always the potential that we could introduce too much flexibility in a way that is unmanageable for both sides.
Another question in the chat, and this gets to the institution of the IRS, and that is, what institutional changes at IRS, as distinct from legal eligibility rules, would help with some of these administrative problems from a more flexible definition?
If I might here on that, I mean, we're going to do a whole separate panel, you know, workshop on that. You know,
which number is that?
That is number 6. So that's
number
2 weeks from now. And I think, you know, I mean, that's just a whole separate topic. I wanted to raise a question sort of based on Emily's research, which I just think is so important. You know, if we're looking, if you found that some, you know, that most of the errors, there was at least some relationship with the child, there was, you know, there weren't a lot of people who were friends or strangers claiming. And so it looked like, if I recall, that a lot of this had to do more with maximizing the credit amount. So one thing that I've been thinking about that's been lost in the discussion of the child tax credit in particular is that when you talk about putting caps on receiving the child tax credit, we seem to forget that the child tax credit, which was derived from the dependency exemption, is in the tax system for all of those 150 million taxpayers who may or may not have children, to reflect their ability to pay taxes because they have a child. And I think maybe if we could get beyond, it might be an interesting way to look at this, to get beyond both the demonizing at the lower end, that this is a handout to people who, if they get it and they shouldn't get, they're undeserving. And then the conversation about the Jeff Bezos of the world, if we could just actually agree that there should be a recognition in the tax system, whether you get money back or you actually reduce your taxes, that it's $3,000 to take care of your child. That's what we're going to reflect in the tax system, regardless of what your income level is. So it is truly a universal benefit in the tax system related to a child. And if you have no income or you're below filing threshold, then it comes back to you in the way of a cash payout. And I think that would be a very interesting way of framing it. And sort of trying to get over the divides and the demonizing. And then, so I was wondering about people's thoughts about that. But the second question that I had was, Australia, to the point of flexibility, allows their credit to be divided between up to 2 carers. So you can agree between yourselves that you are both carers, you're separated parents, but you both have responsibility for taking the child to the doctor, depending on your schedules. You both have, the child stays with one parent, 1 week and the other parent the other week. You agree between yourselves, and as long as only one credit is paid out, the agency doesn't care how you divide it up among yourselves. And I think that that's a very interesting approach. It might eliminate some disputes, and it also moves away this issue of credit maximizing, because there is one credit, and it doesn't matter who takes it as long as only one credit is paid out. So I was really interested in your thoughts about those approaches.
So I would say briefly, I really believe in the don't phase the credit in, don't phase the credit out, just give a universal benefit, because that does, at least eliminate a lot of the gaming opportunities and desires. Len Berman has a proposal out there that essentially does this. And it's, if you don't want high income people to get the benefits, just reflect that in the tax system. You can, tax them back. That's easy enough. And I think what you're sort of talking about, dividing the benefit across households in a sort of loose way, an agreement driven way, makes a lot of sense. I can, you could set the default at both parents get half, and then, they can decide, I'm going to take 75% because the child is mostly with me, and you're going to take a quarter because the child is sometimes with you, to another partner. Shared custody is the most common arrangement for children who aren't living with 2 married parents right now. So it's a big deal. And the research says it's good. It's a good arrangement for kids. And, we ought to be encouraging both partners and parents to participate in this children's lives. And one way you can do that is to recognize it with a child tax credit. And I thought Sarah's comment in the chat was really interesting with respect to this. And she's, sort of wondering if it's even possible. And I would just add to Sarah's point is that it's also costly. There's cost reasons why we have difficulty, doing more flexible eligibility, not just, this administrative issue.
And another point related to the first question and this question is that when this complex set of rules were enacted over time, maybe there was a revenue concern over there. So there is certainly a trade-off between improper payment rate, revenue concern, and who the targeted beneficiaries are. And so as we brought the definition of eligibility, and certainly there is a way to reduce improper payment rate, but also there is a revenue cost there. So I guess we should consider that what is the kind of the revenue consequence everybody could live with. And then with that goal, then whether we should tolerate certain kind of errors or just to give back have some repayment protection. I think there is a trade-off among this different factors. And of course, I think everybody knows that IRS does not have all the information about whether the child lived with the kids for more than 6 months, unless the IRS audit the taxpayers. So again, this goes back to the trade-off between if we want to deliver the benefits to the tax system, and then we will still continue to rely on whether either it's a care criterion or the residency criteria, and there's always some difficulty for the IRS to see that upfront, like whether the person is the truly eligible person. But again, that leads us to the question of then we should tolerate some kind of the improper payment rates as a result, or the errors as a result.
I had several questions in the chat that are specifically about the Ways and Means proposal. Did you want me to ask those, or did you not want that to be
No, go right ahead. Go right ahead.
Yeah, so there was one. So obviously, it's probably the topic of the week is the child tax and the reconciliation bill more broadly. And one of the questions was curious about getting the panelists' take on the caregiving standard. That is the standard that effectively replaces the relationship test with this care for the month test in 2023 through 2025, as Kathleen explained. It would be a monthly determination. So I wondered, getting feedback from people about maybe the costs and benefits of this approach, especially as a replacement for the relationship test.
I'm happy to start with that one. So I definitely think that moving away from the rigid relationship or relative test under the current eligibility rules and towards a more inclusive definition of primary responsibility or care for a child is definitely important for maximizing access to the credit among children with complex family circumstances. And, kids who are moving between households, maybe moving in with folks who aren't their immediate blood relatives. These kids who are in potentially tumultuous or difficult family circumstances are often the ones that need the financial resources that the credit offers the most. And so making sure that we aren't drawing arbitrary red lines is definitely important for maximizing access. These changes would also bring us closer to a definition of qualifying child that we see in other countries around the world with child tax credits or benefits. We didn't focus on this in our paper specifically, but I did look into the qualifying child definitions in Australia, the UK, and New Zealand, and I didn't see any comparable language that specifically enumerates the types of blood relatives or adopted relatives that can receive the credit on behalf of a child. They all used some version of a primary responsibility or care test. And so for those reasons, I think that the changes to the qualifying child rule go in a positive direction. It does, raise the question, maybe that does require more administrative capacity on the IRS's end during audits or disputes to sort of parse through this primary responsibility definition. The advantage of the rigid relationship test is that it is simple for them to sort of decide one way or the other. But, if we had more IRS funding to increase, the administrative capacity of the agency to make these determinations, and also had program navigators to help families, know what documents would work under this new definition, to give families flexibility to use multiple forms of documentation to prove that they meet this new primary caregiving test, I think that those changes could potentially mitigate some of the concerns that we've seen around this move to this new definition.
So I would also,
Sorry, Elaine. I think Nina was just mentioning Canada's administrative presumption on behalf of the mother, and I think that's one reason that didn't make it over into the Ways and Means draft. I believe that's also as a tiebreaker as opposed to sort of a first tier determination, but it's still problematic for that reason. And a lot of the other language that got ported over really pretty closely maps Canada's approach to sort of trying to enumerate what primary primary responsibility or caregiving responsibility means. Was also pleased to see that they did sort of delete or compress some of the limbs of that test from Canada that have proven more difficult in practice than the others. So it seems that lawmakers are looking to other countries in terms of the actual specific eligibility criteria under that. Sorry, Elaine.
No, good. So I think one of the reasons Nina wanted to start this conversation off by talking about all the other definitions that are employed elsewhere is to point out that we actually can administer a variety of standards. We do it in different programs. And the reason we are stuck fitting round pegs into square boxes in the tax system right now is because we have a Congress that has long been unwilling to expand any of those other programs that could be used to provide substantial support to families with children in a broad way. And so tax changes are the only game in town, and it's been that way for a while, for the most part. And so that's why now we're at this crossroads where we have to ask the tax system to do things like transfer systems. So can it be done? Absolutely. We see it being done. Can it be done by the IRS? I agree with other speakers. They need to have the capacity increased. They need to have people that are trained in, social work and the kinds of jobs that are, more adept at administering these types of benefits, and not just be, a collection agency, or as Cathy points out, trying to, get within the nickel of, a tax liability. It's just going to have to be more flexible.
And we're bumping up at around noon, Nina. So I didn't know if you wanted to keep going or.
Well, I don't see more. I see a lot of good comments in the chat. The point about the domestic relations system. I did try to convince Ways and Means to grandfather in the waiver to the non-custodial parent, and going forward, sever the relationship between giving away the child tax credit, since it was such a huge amount of money and now refundable, but I obviously didn't prevail on that one. That's like a kettle of the Pandora's box that nobody wanted to open up. I think this has been a great discussion. I think if we keep in mind these rules and the looking out of disputes, because that's something, that we're trying, that's the next phase. If you're trying to minimize clawbacks and expand rules, do you increase disputes? Do you lessen disputes? And then if you do have a dispute, what is the process for resolving them? And I think Elaine's last point about, and Cathy's point about the IRS, I've always said the IRS doesn't do nuance really well. And that's, in fact, we're asking them not only to do nuance, but also flexibility and not down to the penny. And some of that is a political conversation to have, where you're convincing people that that is sane tax administration. And so that's really the discussion of the next two panels. The first one is due process. What does it mean then to bring these people into the systems, and what happens to people in other benefit agencies? How are disputes handled there? Changes of circumstances. And then how are they handled in the current IRS and, tax arena? And then what should we be thinking about as changes? And then, as I keep promising in every single section, workshop 6 is taking head on, the cultural change that you would need to bring about in the IRS. And there we're going to have some interesting speakers, particularly from the former director of research at the Social Security Administration, who, although everybody holds the Social Security Administration out as this great agency, he has a particular perspective and can comment on some of the culture change that still needs to occur in Social Security Administration. So that's going to be an interesting perspective as well. So thank you all for being here, and thank you, our panelists. This has just been a terrific discussion, and stay tuned for what happens going forward. Thank you all. Bye.